Welcome to This Explainer. If you follow legal proceedings, you already know that a ton of information gets thrown around online every single day. And honestly, it is incredibly easy to confuse what a lawyer says in a courtroom with what is actually an established fact. So today, we're cutting through that noise. We're going to dive into the exact status of 5 major cases for the week of August 24th through the 30th, 2026. We'll be looking strictly at what's verified on the docket, and more importantly, we're going to decode the specific legal phases these cases are entering right now.
But before we get into the cases, let's establish something we call the evidence ladder. Think of this as our framework for today. It is absolutely crucial to remember that court dates don't predict results, and lawyer arguments, well, they aren't evidence. A court date simply tells us what is expected to happen. Opening or closing arguments are just interpretations from the attorneys. Now, recorded prior statements can be admitted, but the jury alone decides how much weight to give them. Actual witness testimony and physical exhibits only become evidence after a judge officially admits them. And finally, at the top of the ladder, we have the verdict. This is a legal decision based strictly on jury instructions. It's never a popularity contest. Understanding exactly where a case sits on this ladder will completely change how you view the news coming out of the courtroom.
All right, so here's our agenda for the week. We're looking at the Lindsay Clancy trial, the Lil Durk federal trial, the Jared Bridegan case, the Tupac Shakur case, and the Lily Peters case.
Let's start with number 1, the Lindsay Clancy trial over in Plymouth County, Massachusetts. In this trial, where Clancy faces murder charges in the tragic deaths of her children, we are stepping right into closing arguments. This puts us at step 2 of our evidence ladder. Remember, closing arguments are essentially the lawyers explaining what they think the admitted evidence means. It is not evidence itself. By the time closings happen, the window to introduce anything new is completely shut. What you're hearing from the prosecution and the defense right now is their final narrative. They're literally taking the puzzle pieces the judge allowed into evidence and arranging them to show the jury the specific picture they want them to see.
The defense officially rested last Friday, August 21st, after presenting testimony concerning her mental condition, so closing arguments are tentatively expected this Monday or Tuesday. Now, keep in mind, courtroom schedules can and do fluctuate all the time. Right now, the Commonwealth is in the middle of their rebuttal testimony, and once that wraps up, we'll move into those tentative closings. After the lawyers finish, the judge will instruct the jury on the law, specifically the rules governing criminal responsibility, and only then do deliberations begin.
It is so important to remember here that Clancy has pleaded not guilty and remains legally presumed innocent unless convicted. The prosecution is moving forward with murder charges, while the defense is heavily contesting her criminal responsibility at the time of the children's deaths. So when you hear all that psychiatric testimony being hashed out in closing arguments, just remember that those are the conclusions of expert witnesses, not necessarily established facts. And once the jury gets the case, the timeline for a verdict is entirely in their hands.
Moving on to number 2, the Lil Durk federal trial in the Central District of California.
Jury selection has wrapped up, with 12 jurors and 4 alternates, which means we are entering opening statements, tentatively scheduled for Monday. Now, unlike the Clancy trial, which is at the very end, this federal trial is at the very beginning of the evidence ladder. Opening statements are just roadmaps. The government will stand up and describe its theory of the case, and the defense will likely point out where they think the evidentiary gaps are. But again, and I can't stress this enough, what the lawyers say here is not testimony, and it is definitely not evidence. Here, prosecutors are alleging a murder-for-hire plot that resulted in the death of 24-year-old Savia Robinson, but Durk Devontay Banks, known as Lil Durk, and his co-defendants have pleaded not guilty. The prosecution's claims that Banks ordered, financed, or planned the killing are, at this stage, purely allegations. Every single defendant in that courtroom is presumed innocent unless and until proved guilty. As we watch this trial kick off, the jury's real job is to filter out the noise and focus only on the actual evidence admitted during the trial. Up next is number 3, the Jared Bridegan case, specifically the Mario Fernandez Saldana trial. This trial is deep into the witness testimony phase, meaning actual evidence is actively being presented for the jury to evaluate. So we are squarely on step 4 of our evidence ladder. This is the real meat and potatoes of a trial. Information, documents, witness statements, they're all being heavily scrutinized, run through the strict rules of evidence, and if the judge admits them, handed over to the jury to weigh. Saldana is facing first-degree murder charges in the 2022 death of the 33-year-old father, but he has pleaded not guilty and, of course, is presumed innocent. Opening statements kicked off back on August 17th, and by last Friday, jurors had already sat through 5 full days of testimony. Now, the court completely controls the daily schedule, but we expect this rigorous process of examining witnesses and admitting exhibits to carry on throughout this week.
Because there are related prosecutions tied to this specific case, it is incredibly vital to keep the facts separated. The jury in Fernandez Saldana's trial is only looking at the evidence presented against him. Whatever ruling comes out of this courtroom does not automatically dictate what happens in the separate proceeding for Shanna Gardner.
Case number 4 takes us to Nevada for the Tupac Shakur case, the Duane Keffe D. Davis trial.
Jurors recently heard a recorded 2008 police interview. In legal terms, this is classified as a recorded prior statement. It is not a brand new courtroom confession from the witness stand. This lands on step 3 of our evidence ladder, and honestly, it's a phase that causes a massive amount of public confusion. When a jury hears a recording of a defendant speaking, the headlines inevitably make it sound like the defendant just stood up in court and confessed to everything. That is simply not what's happening. Davis didn't magically become a trial witness just because the jury heard his voice on a tape from 2008.
Davis pleaded not guilty to murder with a deadly weapon. Yes, he described the shooting in that tape, but it's entirely up to the jury to decide how reliable that prior statement actually is. The recording was admitted into evidence, sure, but the jury has to evaluate the context. They'll scrutinize the conditions under which that 2008 interview was made, they'll hear the defense's arguments about its reliability, and they'll weigh it against all the other admitted evidence. Davis is presumed innocent, and that tape, it's just one piece of the puzzle.
And finally, number 5. We are heading to Wisconsin for the Lily Peters case, the Carson-Petersberger resolution hearing.
The most crucial takeaway here is that a resolution hearing does not automatically mean a plea, a sentencing, or a dismissal has happened, not until the court actually accepts or orders it. Legal terminology can be really tricky, right? A resolution hearing certainly sounds final, but we can't jump to conclusions. It's basically a placeholder term for a proceeding designed to find an end to the case. The actual mechanics of what that end looks like remain completely unconfirmed until the judge officially acts on the record.
Petersberger, who was a juvenile at the time, faces charges including first-degree intentional homicide in the death of his 10-year-old cousin, to which not guilty pleas were entered. Because he was 14 at the time of the alleged offenses, he is being prosecuted in adult court. But like everyone else we've discussed today, he remains presumed innocent unless and until a conviction is entered. Looking at the timeline here, the charges originated in 2022, and a full jury trial has been scheduled for this November.
We expect a tentative hearing on Wednesday, August 26, to resolve the case without needing that November trial, but we simply cannot predict the outcome until it actually happens. The district attorney's office has indicated that the proceeding should bypass the trial, but the exact terms of whatever agreement they have are completely shielded from the public right now. We'll only know what kind of plea or procedural action has been taken once the court formally accepts it.
From tentative closing arguments in Massachusetts to opening statements in California, and from analyzing prior statements in Nevada to waiting on unconfirmed resolutions in Wisconsin, these 5 cases show exactly why understanding the legal framework matters so much. The true story of a case is found in the rigorous legal process itself, not just the flashy headlines.
So, as we step off the evidence ladder for today, how will these specific legal processes actually unfold in court this week? Track confirmed dates, tentative listings, and updates at the Cassian Creed Court Calendar at cassiancreed.com/court-calendar.